David Chesnoff, Rich Schoenfeld, present with Her Honor, Stefany Miley.
Ross Goodman on behalf of Bret Parker, who has not been served.
And Your Honor, Louis Palazzo appearing on behalf of Jason Dean, who's named in the application on page 6.
Thank you. He's not a named party here, but I'll address that in a moment.
Thank you, Your Honor.
And then on behalf of the applicant.
Good morning, Your Honor. Good morning, Your Honor. Bruce Gale, bar number 3413, as an applicant, appearing in proper person.
Thank you. Before we start, I'll just make the disclosure that I know both of the parties, or at least Mr. Gale I know, and Judge Miley I know personally. I do not know the other party here, Mr. Parker. I may know Mr. Dean. From my review here, he appears to be a marshal.
Correct, Your Honor.
And he's not present. Is he present?
He is not present.
He's not present.
served.
If I saw him, I might recognize him. And I'll just make the disclosure that I know both individuals, Mr. Gale and Judge Miley, having met them both at social functions, legal functions, campaign functions, but nothing about my knowledge of either parties I think would preclude me from presiding over the case. It's just normal social interactions. We're all in the legal profession. Would any side like to be heard?
We have no issue, Your Honor.
No issue, Your Honor, but I think I'd like to take care of some preliminary matters that might resolve this as far as possibly continue this case. I subpoenaed Brandon Troush. He was the account manager. He was the primary witness to the events on Sunday, June 23rd, 2019. Can I approach, Your Honor? I didn't have time to file this. This is the original summons.
Has counsel seen this?
I'll give a copy of this.
No, Your Honor.
I'll give it to counsel.
For the record, Your Honor, Mr. Gale knows that I'm the judge's attorney and has not served me with anything.
Well, Your Honor,
You're too busy being on television being interviewed.
excuse me, Your Honor. I did not know Mr. Chesnoff was Ms. Miley's attorney in this matter. This is the first court appearance. There's been no appearances, so the statement is untrue.
What is your request?
Okay, so, and I've also have a subpoena for the custodian of records.
And Your Honor, can I ask one thing before Mr. Gale proceeds, because I don't think it applies to my client. There's been no service on Bret Parker, so.
Let's take these preliminary matters one at a time. I was going to address that.
Okay.
Also,
Okay.
counsel,
Thank you,
I'm
Your
aware of
Honor.
that issue. But let me hear first from you.
So, Your Honor, so I've subpoenaed two witnesses. They're not present. They haven't appeared. According to Justice Court Clerk's office, they've made 5 attempts to serve Bret Marshal Parker, been unsuccessful, and unless the applicants want to stipulate to grant the protection order, which I don't think they do, I want to continue this matter because I want my primary recipient witness present.
Your Honor, first of all, we did accept service for Her Honor, so Mr. Gale was aware that we were the lawyers. Secondly, he just did this yesterday, even though that he found time, Your Honor, to appear on television and talk about this case, which has its own ethical issues, being a member of the bar. But he's dilatory, not diligent, not proceeding, and when you couple it with the failure to serve, and in one instance serve somebody who shouldn't even be remotely connected to this, his conduct doesn't mandate any kind of consideration for continuing this. This is important to Her Honor, and we're prepared to address the contents of his original application.
Thank you. This was set for hearing some time ago.
That's correct, Your Honor. I didn't find out till fairly recently when I got a letter from Justice Court Clerk's office that Bret Marshal Parker had not been served. Again, Mr. Chesnoff has represented Ms. Miley in the prior domestic violence case, but there's been no appearance of him in this case. So he never contacted me and let me know he was representing Ms. Miley. And again, I have subpoenaed 2 witnesses, and he is the primary percipient witness to corroborate factually what happened. I attempted to serve Ms. Miley, my process server was successful in trying to attempt to serve her yesterday. She's here today, but anyway, I'd like a brief continuance because I want Brandon Schroeder's share.
For the record, Your Honor.
The application was filed on July 26th. The same day I did, or possibly the next business day, I did sign an order setting hearing. I see a letter dated July 29th from the Las Vegas Justice Court to Mr. Gale indicating you are hereby notified that a hearing is set for the court to decide whether a temporary protection order should be issued. So the applicant, Mr. Gale, has been aware for some time of this hearing. This appears to be a subpoena prepared yesterday. Request to continue tonight. Any other preliminary matters?
No, Your Honor,
Okay.
just with respect to Mr. Parker.
And I'll address that.
Thank you.
We're here to...
Your Honor, may Her Honor be seated?
Absolutely. At any party may be seated. We're here to consider the ex parte application for a temporary protection order filed on July 26th by Mr. Gale. In it was a request for a hearing for an extended protection order. The request for temporary protection order was not granted. Instead, both requests for temporary and protection order and extended were set for hearing today. So as a preliminary matter to address service, I do have an affidavit of service, of attempted service, as to Mr. Parker. Now, Clark County Sheriff's Civil Division was unable to serve Mr. Parker notice of this hearing. So I'm inclined to simply deny the request for an extended order against Mr. Parker based on procedural grounds. Would you like to hear this, Mr. Gale?
Your Honor, no other than that, they've apparently made 5 attempts to serve him. That's why I was told.
Correct. And I'll note that I do have an affidavit here of attempted service indicating attempts to serve Mr. Parker on August 1st, August 6th, August 9th, twice on August 9th, and on August 16th, they were unable to serve him. So as to Mr. Parker, the application, the request is denied, yes.
Again, I would request that the temporary protection order be granted regarding Mr. Parker. I know he has obviously evaded service. 5 attempts to serve him at his residence address, unsuccessful. And
Now, to be clear, I'm denying the request for any extended order, but a temporary order, I guess, may still be granted, depending on how the case proceeds. So,
Well, Your Honor, I would submit to Your Honor that the procedure requires service of the notice of hearing. And
for an extended, I would agree.
okay. And I just need to have a ruling on that, because if the court does deny it, even a temporary order, then it doesn't require me to be present and participate in the hearing. Otherwise, depending on what the court decides, I'm going to have to remain and participate.
Well, there's been a renewed request for a temporary order, so that, I guess, it is still possible that a temporary order, only a temporary, may be granted. So I'll address that in a moment. As to Judge Miley, I see that she was not personally served. Counsel already mentioned Mr. Chesnoff accepted service on her behalf of notice of this hearing. I did review the application, and rather than a statement of facts, the application refers to a number of exhibits, and I have reviewed those exhibits. Filed along with the application was a 41-page exhibit packet. The first exhibit includes a 9-page statement of facts prepared for Las Vegas Metropolitan Police Department pertaining to an incident on June 23rd of this year at Lifetime Athletic. To summarize, Mr. Gale alleges contact with the adverse parties on this date at this location, and he breaks the contact down into 3 parts. The first part, Mr. Gale alleges that while there on a tour, after just joining, he observed Judge Miley, who said to Mr. Gale that she wanted to introduce her boyfriend, and that an individual who Mr. Gale identifies as Mr. Parker shook hands with Mr. Gale, and immediately after the handshake, Judge Miley said, and I'll quote, in quotes from this statement of facts, "Bruce is the attorney who called the cops on me." And immediately thereafter, Mr. Parker said, and again in quotes from the statement of facts, "You better get him out of here quick before I kick his ass." That Mr. Gale said nothing and walked away. Mr. Gale goes on, the second incident, that Judge Miley approaches him and tries to talk to him within 10 seconds and approximately 60 feet of the first incident, and that Mr. Gale again said nothing and walked away. As to the third incident, Mr. Gale indicates that shortly thereafter he was walking to the cafe, and when he exited an elevator, and Judge Miley was again right in front of him and tried to talk to him, and then he again said nothing and walked away. Now that's the first exhibit attached here. The second exhibit is a Las Vegas Metropolitan Police Department report pertaining to the incident on that date at that location. Exhibit 3 is a screenshot, appears to be a screenshot of a months earlier text message conversation between individuals not a party to this action. Exhibit 4 appears to be a Las Vegas Review-Journal article about an incident involving Judge Miley, again from an incident months earlier. Exhibit 5 is another Las Vegas Metropolitan Police Department report from an incident involving Judge Miley, totally separate from all of these other incidents. Exhibit 6 appears to be a portion of a Las Vegas Now article about that incident. And Exhibit 7 appears to be a portion of a Google search result for the search terms of Stefany Miley's soccer incident. I should also note that Mr. Gale is requesting that the adverse parties be ordered to stay away from his home, his place of employment, and Lifetime Athletic. And he is also requesting that the adverse parties be ordered to stay away from an account manager at Lifetime, and I believe that's this Mr. Trochi, who was mentioned earlier as a subpoenaed witness. Mr. Gale is also requesting that Judge Miley's judicial marshal be subject to the same conditions of any potential order.
Thank you, Your Honor.
Mr. Palazzo, that I believe is Jason Dean, is that correct?
Yeah, if I could make some comments regarding that at the appropriate time. If you want me to do that now, I will.
Just, how about procedurally, before we start talking about any facts of the cases, procedurally?
Procedurally, to have gratuitously included Mr. Dean on page 7 of this application, I think is misplaced. I think it's inappropriate. There's no factual or legal basis to have included him. There are no allegations against Mr. Dean. I think it's a reckless act on the part of Mr. Gale, especially with someone who's in the law enforcement career, to be subjected to this, where his career could be adversely impacted. This application and the contents of this application seem to me to be a very thinly veiled abuse of the legal process, and seems to be in furtherance of Mr. Gale's political and judicial ambitions, and it shouldn't be done on the back of someone like Marshal Dean.
Would you like to respond to that, Mr. Gale?
Yes, Your Honor, briefly. I included Mr. Dean based on information I had. Secondly, I am not doing this in furtherance of my political and judicial career. Nothing could be further from the truth. I don't go looking for a fight. And I sure as hell don't back down from one. So I didn't start this. So I'll simplify this. I don't have any problems if Mr. Palazzo wants to, I'll leave it at your own discretion, Your Honor, what you want to. Yes, he's technically not a party. But I had concerns about him because he's works for Judge Miley and things that I've heard, so.
Well, to have gratuitously included him without any basis whatsoever factually or legally is wrong, and even more wrong as a officer of the court, and he should know better.
Thank you. Mr. Dean is not a party to this. He was not served with notice of this. He does not appear anywhere in the exhibits. Any mention of him does not appear in any of the exhibits that I've mentioned. So, no orders will be granted against Mr. Dean today, and he's excused from this
Thank
case.
you,
So
Your Honor.
I'll leave it up to you, Mr. Palazzo. If you'd like to stay, of course you can.
Thank
If you need to leave, you can leave. So again, we're here for Mr. Gale's request, so we'll begin with Mr. Gale. I'll hear first from the applicant.
Can I call a witness, Your Honor?
Yes.
I'd like to call Judge Miley. That was witness.
Court's involved. Your Honor, before he gets to call, he has a prima facie burden of proof based on the.
That's what I was expecting, is just a statement of facts first from you about
Okay.
why a protection order is needed, what gives rise to what allegations give rise to the need here. So.
Especially since facial analysis of his allegations do not even remotely meet the elements required, so I think you should address that, Your
So
Honor.
begin with that, Mr.
I don't agree with Mr. Chesnoff's characterization, Your Honor. Your Honor, it's undisputed that on Saturday, December 22nd, I called Las Vegas Metropolitan Police regarding domestic violence incident involving District Court Judge Miley. And I don't need to go into what happened with that case. But suffice it to say, I would not win a popularity contest with Judge Miley. And that's an understatement. Number two, I ran into her, and there was about a 5-second delay, as I've stated in my statement. Now, my head was turned to the right, and I immediately turned it straight, and there's Miss Miley about 2 to 3 feet in front of me. And that 5-second delay.
Your Honor, could Mr. Gill address Her Honor as Her Honor a judge, not Miss Miley, please? Thank you.
Sure.
Proceed.
Sure. Yeah, that's fine. So, she did not move in those few seconds. She is the one who initiated and set this whole chain of events in motion. There's no rational reason except, I'll strike that, Your Honor. I want Your Honor to query, why would she introduce me to her boyfriend? I'm not a friend of hers, and that's an understatement. She knows her boyfriend, and I'll leave it at that, Your Honor, and we'll maybe get into that later. But she is the one who started the chain of events of constituted harassment. And again, you know what happened. And her boyfriend said to Brandon, "You better get him out of here quick before I kick his ass." And I immediately turned around, Your Honor. I was extremely bothered by that and threatened and had reasonable fear of bodily harm. And I can meet all of the elements of NRS 200.571. Just the factual allegations on their own meet all the elements of NRS 200.571, the harassment. Now, the harassment didn't end there. Miss Miley, about 60 feet later,
Miss Miley again.
excuse me, Judge Miley came and caught up with me. And she was on my left, and she said, all I heard, and I said this in my statement, "Dallas loves the photographs of me." Now, she knows Dallas Horton. I know Dallas Horton. Her husband knows.
Ex-husband.
Ex-husband, well, I didn't know the divorce has been finalized, Your Honor. Bottom line, we're all from Texas. So we all know each other from being in the legal career. So I believe that's what she was discussing, the reference. Did she retract her statement? Did she recant her statement? Did she, or her boyfriend's statement? Did she apologize? Hey, Bruce, I'm really sorry about what happened with my boyfriend. No, she didn't. So, after that, I go down to the offices at Lifetime Athletic. Brandon and I part ways. And then shortly after, I see her.
Before you get to that incident, tell me how long and how close in proximity did the second incident happen?
When she caught up to me?
Yes.
Well, I was walking down the aisle, Brandon. She was right to my left. She caught up from me behind on my left.
That's what you said, she caught up. How long did it take for her to catch up?
Well, I said in my statement, I think I said a matter of I don't know how many seconds.
10 seconds.
And the reason why I know about the width of the aisle and the seconds is because after the incident, I went back and I walked the length of the aisle.
I'm just, how are these two separate incidents, I guess is what I'm trying to determine.
It's continuing, it's a succession of 3 continuous harassments. The first confrontation and the threat. The second one, wanting to talk to me again. And I'm also, although I've never entered a formal appearance, I represent her husband in the divorce, potential witness of the divorce at the time. It's a whole host of other ethical issues. And then the third incident. I call it the third incident because there was another incident where I saw them and I avoided them. I shouldn't have to, I just joined the athletic club. I should not have to feel threatened, be in fear, reason why I have to avoid them. So then the fourth incident, or the third actual incident where there was contact, all I heard her say was, a mom wants. And I did 180 degrees, walk the opposite way. Excuse me, it wasn't exactly 180 degrees. From going towards the Lifetime Cafe, down towards the aisle, the hallway where it leads to the women's locker room. So that's the facts, Your Honor.
So clear up for me, the Lifetime Athletic, I believe it's called, it's a gym?
Yes, it's
Multi-levels, multi-stories?
3 stories.
3 stories, and obviously there's a cafe. Is it the cafe attached inside the
Cafe is right when you walk into the front entrance. The cafe is on your right.
Thank you. Continue.
Okay. So that's factually what happened, Your Honor. And the primary precipitate witness, Brandon Troush, is not here. Tried to subpoena, serve a subpoena. My process server tried to serve a subpoena on Miss Miley. Yesterday was unsuccessful. I want to call her as a hostile witness, Your Honor.
Thank you. I'm going to hear next on behalf of Ms. Miley.
Thank you very much, Your Honor. Your Honor,
I said Judge Miley, excuse me.
thank you very much, Your Honor. At least Ms. in this day and age would be nice. Everything about the interaction that Her Honor had with Mr. Gale is lawful, protected, free speech, not containing a single threatening statement whatsoever. Hello, I'd like you to meet my boyfriend. They shake hands, which he doesn't run away, shakes hands, and then allegedly, without any corroboration whatsoever, because he was dilatory in preparing for this hearing, we have a statement allegedly made by somebody else, not Judge Miley. She told the truth to her boyfriend. Mr. Gale has proclaimed loudly to whoever will listen that he is the person that called the police on Judge Miley for a case that was denied by the Nye County District Attorney based on the evidence, not the rantings. They analyzed the entire case, they analyzed the police reports, they analyzed statements made by the parties. and they did not even believe there was probable cause to bring the domestic violence case against Judge Miley. She reported to her friend that this is the gentleman that did that. He took pride in doing it. He hasn't hidden it from anybody. She wasn't revealing a secret. In fact, as of, I guess, last night, he was on television in an interview declaring that he is the person that ratted out falsely, apparently, or at least lack of probable cause why Judge Miley. And then the subsequent comment about the mugshot, is Judge Miley declaring the truth that there's this terrible picture of her taken on a charge that she was never prosecuted for. So she expressed that. There's nothing about anything that Judge Miley did that rises to the level of statutory elements or any form of harassment or restraining order. Zero. As it applies to her, there's no reference that she told, if her assuming arguendo, her friend said what he alleges, there's nothing at all to suggest that she prompted that in any way. And to subject her to further indignity by requiring her to answer questions from him when it doesn't meet the statutory standards on the face, now he's had a chance to make an offer of proof to you, Your Honor, which wholly fails.
Argue that. Tell me, you're arguing that this does not meet the statutory requirements here. What is your argument?
I'll read them to you. I have to pull them up again. I turn my phone off.
That's how I come down on this case right now. I don't think there's going to be a lot of dispute. If I were to allow Judge Miley to testify as to the comments, I think it might be very similar to what's been stated here. The actual contact, the actual communication, what was said. If I were to even hear from the other alleged or the other adverse party here, or if I were to hear from the witness, Mr. Trouch, the account manager at Lifetime Athletic, I wouldn't be surprised if he said the exact same thing Mr. Gale has stated here today. I'm wondering if this conduct here does fit within the statute of what needs to be shown. This is an application for protection order against harassment, stalking, or aggravated stalking. So those are defined by statute. I'm wondering if this conduct fits.
Assuming arguendo, or accepting the facts in the offer of proof, it does not meet the statutory requirements of 20.571. It says, without lawful authority, the person knowingly threatens. There hasn't been a knowing threat shown by anything that Mr. Gale said, Her Honor stated. To cause bodily harm in the future, the person threatens or any other person. She never threatened any bodily harm in any way. To cause physical damage to the property of another, that's not been alleged. To subject the person threatened or any other person to physical confinement or restraint, she didn't do that on the facts as presented. The person by words or conduct places the person receiving the threat in reasonable fear that the threat will be carried out. There were multiple contacts at the place that we're talking about with multiple opportunities to carry out the acts. Nothing happened. There's not even an allegation that someone clenched a fist. Words alone, Your Honor, if from her mouth, potentially could qualify. But in this instance, nothing that she said could be construed under any English language definition of harassment or threat. Based on that, Your Honor, the harassment charge is bordering on absurd. I don't think I need to go into the stalking part, Your Honor, because this has been alleged as harassment.
Thank you. And why don't I hear on behalf of Mr. Parker also, and again, Mr. Parker, am I considering any extended order against Mr. Parker? He was not notified, at least was not served with notice of this hearing, so on procedural grounds I cannot proceed on an extended order, but temporary orders may be granted ex parte. That was previously set for hearing today, so let me hear from counsel as to that argument.
Thank you, Your Honor. I think just to follow up on what Mr. Chesnoff read as part of the statute. The only, taking Mr. Gale at face value, which we don't, but just taking what his statement of facts that he alleged, there was no, based on the 3 words at issue here, there was no reasonable fear that Mr. Parker would carry out a threat. He hasn't alleged one, and in fact, he's demonstrated himself that there was affirmatively no reasonable fear that Mr. Parker, assuming he made those, that statement, would be carried out, because there was 2 other interactions, none of which Mr. Gale alleges Mr. Parker said anything else threatening. He didn't clench a fist. He didn't make an aggressive movement towards Mr. Gale on 3 occasions. Secondly, Your Honor, the alleged kick your ass statement was directed to the account manager, Mr. Touche. It was not, in Mr. Gale's own words, it wasn't even a threat directed towards him. It was saying to the account manager, you better get it out of here. And Mr. Gale's whole statement relies on this account manager. And as he told you at the beginning, the basis to renew the temporary restraining order, the application, was because he subpoenaed this witness, which he characterized as a critical witness, a pivotal witness. But yet, he filed this application 30 days ago, and he doesn't attempt to subpoena the critical witness until 4/27, the day before the hearing. That's the best evidence that is speculation on what the account manager would say, because if he was that critical, you know, the court knows that he would have been subpoenaed shortly thereafter the filing of the application. Mr. Gale's statement of facts, Your Honor, also confirms that he went over to Stefany Miley. He went to Judge Miley. He extended his hand to shake Mr. Parker's hands. He didn't walk away. The account manager, who's the account manager for lifetime, didn't intervene. There's no evidence that he told Mr. Parker, you had to leave. We don't tolerate that behavior here. There's none of that circumstantial evidence or cooperation that one would expect to see if there was really a threat that was done at Lifetime. And the court knows that as well, because Lifetime Fitness is a multi-story facility. There's hundreds and hundreds of people there at any one time. The way that Mr. Gale just described the interaction, I would assume that there was 50 or 60 people within inches of this interaction. And not only did no one make a statement or go up to Mr. Gale to say anything, or Mr. Gale went to them to say anything to get a witness statement, but the account manager who allegedly heard this, whose words it was directed to, took no steps to try and resolve the issue. So there is no evidence based on the statement of facts today that Mr. Parker was going to carry out, assuming those words were even said, a threat. And I would also note the obvious to this court, which is that there's been 30 days since the application's been filed, and there's been no evidence or allegation there's been any interaction with Mr. Gale and Mr. Parker.
And I meant to ask that immediately. Anything else to add, Mr. Goodman?
No, Your Honor, thank you.
Mr. Gale, is that a correct statement? I meant to ask you that earlier. There's been no contact between any parties since this incident?
I'm not aware of any attempts by Mr. Parker to follow me or anything. I don't know, Your Honor. I can't say there definitely was. I can't say there definitely was not.
What's your response?
Okay. Your Honor, I just want to correct couple serious factual misstatements by Mr. Goodman. He said, I approached Judge Miley. Nothing could be further from the truth, Your Honor. I was there on a tour of the facility. Can I use your marshal for a very brief enactment, Your Honor?
Yes.
Okay.
For distance reasons.
So, Your Honor, so this is Miss Miley, Judge Miley. This is Bret Marshal Parker right here. And there's machines. They're real close to the machines on this side of the aisle, not this side of the aisle. And I'm walking straight ahead, and I'm looking to my right. And then this is how close I was to Miss Miley. I believe she saw me coming. I don't know that for a fact. And Your Honor, I'd like to test the credibility of her. Let me put her on the stand, Your Honor. She's present. They're making all these oral arguments, but I'm denied the opportunity for a continuance, for my recipient witness. You know, they want to make a big issue of my dilatory, my subpoena the witness, you know, the day before. Let's deal with the facts, Your Honor. So, Miss Miley this is how close I was. And couldn't go this way. And this is in a matter of literally about 5 seconds, Your Honor. That's how short a time lapsed from when she turned to her left and said, I want to introduce you to my boyfriend. Now, I don't like her. She doesn't like me. I think that's an understatement. I think there's no secret. So it's not like we're friends. Hey, Bruce, I want to introduce you to my boyfriend. No. And so, Your Honor, it was a knee-jerk reaction. Yeah, sometimes people put their hands out, and I don't like them. I won't shake their hand. But it was an involuntary movement. It was just something I did quickly. And then she immediately said, Bruce is the attorney who called the cops on me. I've never met Bret Marshal Parker. Don't know him. And he said to me, he threatened me. He said, and it wasn't just directed to Brandon, it pertained to me. Okay? There's not going to be there's not going to be bodily harm inflicted on Brandon. It's going to be me. And he said again, you better get him out of here before I kick his ass. So, I could laugh at him. I could, initiate a fight. I did the right thing, Your Honor. I believed at the time. I walked away. And they're making a big deal out of that, and that there were other opportunities where Bret Marshal Parker could have inflicted harm on me. Your Honor, if he's smart, and I'm sure he is, he's not going to do it in a public place where there's potentially many witnesses. So I want to discuss that. Now, regarding Mr. Goodman's statement that Brandon Troche should have intervened. He's not the general manager of Lifetime Fitness. He's an account manager. And when you walk in the facility, to the left is, there's persons where they check you in, you scan your card. The Lifetime Cafe is to the right. To the left are some offices. There's probably maybe 5 or 6 offices. And these are all salespeople. So he's just one of many account managers. And at the back of that office is the manager's office named Chris. So why would Brandon intervene and get involved in a physical altercation? So I think that statement by Mr. Goodman that Brandon could have intervened, I think is without merit. So let's deal with the elements, Your Honor. I've mentioned in my statement NRS 200.571, the harassment statute, NRS 200.575, the stalking statute, and I also mentioned aggravated stalking, okay, and also conspiracy to commit harassment, conspiracy to commit stalking, and conspiracy to commit aggravated stalking. Again, Your Honor, apply your common sense. Why would Judge Miley introduce me to her boyfriend? For not a good motive, Your Honor. Now, I want to go through the elements of the harassment statute, 200.571. A person is guilty of harassment if, without lawful authority, the person knowingly threatens to cause bodily injury in the future to the person threatened or to any other person. To cause physical damage, right, I'm sorry, subsection 1A, I meant in subsection 1, 2 doesn't apply. Okay, subsection 1(3), to subject the person threatened or to any other person to physical, okay, forget about that, I'm sorry, Your Honor. Subsection 4, I'm sorry, Your Honor. To do any act which is intended to substantially harm the person threatened or any other person with respect to his or her physical, mental health, or safety. Subsection B, the person by words or conduct places the person receiving the threat in reasonable fear that the threat will be carried out.
So that's my question.
Okay, so.
You mentioned it multiple times, and I'll refer to page 7, page 8, and page 9 of your exhibits. You mentioned, and I think this was in the context, and you mentioned it here in your arguments today. You mentioned again on page 7, 8, and 9 in the contents, and I'll read from your exhibit, your statement of facts. I'll quote, again, and most importantly, I definitely did not hear Stefany and Miley say anything regarding her immediately preceding introduction of her boyfriend, Bret Marshal Parker, to me, nor his immediate threat to kick my ass. No apology, nothing. And you really emphasized that today. And you indicated here that that made you feel, you mentioned multiple times bothered, and you mentioned one time extremely bothered. In court today, you again referred, and I wrote down exactly, you said you were extremely bothered by this conduct. But today, and I think this is the first time, you did indicate you felt threatened and in fear of bodily harm. Did you feel threatened and in fear of bodily harm by this statement?
Yes, I did, and I said that earlier, Your Honor. I believe I said that earlier. So, you know,
because that is required by the statute. This may fall under sub 4 of the harassment statute, to do any act which is intended to substantially harm the person threatened or any other person with respect to his physical or mental health or safety. But there's an additional portion that needs to be shown here, is that the person by words or conduct places the person receiving the threat in reasonable fear that the threat will be carried out.
Okay, Your Honor.
Did that exist here?
Yes, it did, Your Honor, and I'll address this. All right. There's no question about the content of Bret Marshal Parker's words.
Your Honor, just so the record's clear, for purposes of your analysis today, we are accepting the offer of proof only for that. Nobody here is agreeing that this gentleman said any of the things that Mr. Gale claims.
Understood.
I want that clear for
just arguments here. There's been no testimony provided, but continue.
But assuming, go ahead.
Okay. All right, Your Honor. And again, if they want to question those statements, let me put Ms. Miley on the stand.
Your Honor, just making a record.
Okay. Well, they're making a big deal of it, so I'd like you to be able to opportunity to put Ms. Miley on the stand, or anyway.
Continue.
Okay. All right, Your Honor. So there's no question. Bret Marshal Parker, he knowingly threatened to cause bodily injury in the future to me. No question about it. You better get him out of here before I kick his ass. Okay? Now, I've represented Edward Randy Miley in the divorce case. And I've heard things about their marriage, tortured history, and I've heard things, I knew things about Bret Marshal Parker. But anyway, I haven't been threatened probably since, junior high school. And so I took that threat seriously. There were other people that I was with at Lifetime Fitness, but I don't want to get them involved in this, okay? And so suffice it to say, the words or conduct, it placed me in reasonable fear that the threat will be carried out. I don't even know this guy. And again, she's Judge Miley's boyfriend, her lieutenant. He'll do whatever she wants, potentially. It bothered me then, and then the next day, I was at Lifetime Athletic, and I pulled into and I didn't put this in, I pulled into the parking lot.
Well, then we're gonna object, Your Honor, if it's
Okay.
not in the petition.
Okay.
It's not in that.
Well, no, you're asking me about if I felt a reasonable fear. And it doesn't just pertain to that immediate moment.
It's okay, he's saying he went back to the place that he felt afraid of.
Mr. Gale, and to clear up for me too, you did stay there, right? You stayed, and you in fact went to the cafe to get something to eat?
I was meeting some people there, Your Honor.
And in fact, after the third incident, you did in fact go to the cafe and stay there?
Yes, I was supposed to meet some people there, Your Honor.
Thank you. Continue.
Yeah. Doesn't mean that I wasn't bothered about what happened, Your Honor. Now, also regarding subsection 4, to do any act which is intended to substantially harm the person threatened or any other person with respect to his physical or mental health safety. Again, if you better get him out of here before I kick his ass. If that's not intended to substantially harm me with respect to my physical or mental health or safety, I don't know what is, Your Honor. All right. So, I think I've met the elements of 200.571 regarding harassment for certainly Bret Marshal Parker and request a temporary order for protection. Now, back to Miss Miley. Again, I've let
Judge Miley, Your Honor.
Judge Miley. She is the one who set this in motion, Your Honor. And she didn't introduce me to her boyfriend for some detached, disinterested generosity or some other benevolent purpose. She doesn't like me. And I'm representing her husband in the divorce. I'm a potential witness in the divorce. So, let me intimidate. Let me introduce Bruce to my boyfriend. Okay? And that'll maybe he'll back off. Again, Your Honor, there's no rational reason why she did such. Now, regarding the stalking, NRS 200.575. Okay, subsection 1. A person who without lawful authority, and again, I want to go back to without lawful authority, the section in the harassment section. There's Bret Marshal Parker, he's not a police officer. He didn't have any legal authority to threaten me. All right, so anyway, that's a minor point, Your Honor. So NRS 200.575, subsection 1. A person who without lawful authority willfully or maliciously engages in a course of conduct that would cause a reasonable person to feel terrorized, frightened, intimidated, harassed, or fearful for the immediate safety of a family or household member, and actually causes the victim to feel terrorized, frightened, intimidated, harassed, or fearful for the immediate safety of a family or household member, commits the crime of stalking. All right, I'll stop there, Your Honor. Now, again, Bret Marshal Parker, he had no legal authority. He was willful and malicious. Doesn't know me from Adam. Never even met the guy. And I did feel, not just then and afterwards, I felt terrorized, frightened, intimidated, harassed, or fearful. Based on, again, what I have heard about him and his actions and his conduct. He doesn't know me from Adam. Never met the guy. But he's Judge Miley's henchman. Okay. Your Honor, so I think I've met the definition of NRS 200.575 regarding Bret Marshal Parker. And again, the aggravated stalking section, Your Honor,
That would require a finding of a placement in fear of death or substantial bodily harm. Does that apply here?
well, I'm gonna kick your ass. Could be death, could be substantial bodily harm, weapons. Okay. Anyway, Your Honor, regarding Ms. Miley, again, the conspiracy to commit the stalking. Again, I won't repeat what I said. There's no rational reason why she didn't do speak to her boyfriend. And we knew what might follow. And if you have any doubt about that, Your Honor, about imposing a protective order, let me have the opportunity to put Ms. Miley on the stand. She's here. And subpoena.
I have very little doubt that the conduct that Mr. Gale has alleged here actually happened. However, what I need to determine is whether there was a reasonable fear that the threat would be carried out, whether the conduct here is conduct that would cause a reasonable person to feel terrified, frightened, intimidated, or harassed, and that conduct actually caused Mr. Gale to feel terrorized, frightened, intimidated, or harassed. Harassment by statute is a person commits a crime of harassment when a person without lawful authority knowingly threatens to cause bodily harm in the future to the person threatened or any other person, or any act which is intended to cause substantial bodily harm to the person threatened or any other person with respect to his physical or mental health or safety, and the person, by words or conduct, places the person receiving the threat in reasonable fear that the threat will be carried out. This court would not benefit from any additional testimony here. Again,
Can I have one more comment, Your Honor?
Wait, Your Honor, can I respond? I mean, Mr. Gale had like 30 minutes of this argument.
What's your response?
All right.
You had not a response. You had one more point you said?
Yeah. Your Honor, I probably have spent about 100 hours on this, lost a lot of time, lost a lot of sleep. And I have been looking over my shoulder. Your Honor, I'm not doing this to pursue my political or judicial career, as Mr. Goodman said.
I didn't say that.
What's right and what's wrong is wrong. And what was wrong was happened. Again, Your Honor, I didn't go looking for a fight, but I'm sure as hell not backing down from one. So, Your Honor, I take the conduct what happened seriously, Your Honor. I had concerns about filing this application for protection order, because then it might infuriate Mr. Parker more, but I need to make a public record of this in case something happens to me. And so, Your Honor, I'll leave it at that.
Thank you, Your Honor. If I can just bring this full circle, I'll be brief, just to sum it up. I mean, Mr. Gale's reenactment, I think, demonstrated clearly to the court and everybody here that he did approach Judge Miley. He said, again, in quotes, "Get this guy out of here." That's a statement directed to a third party, assuming that it was said, not to Mr. Gale. There was no act. It was just words. There was no action or ability to carry it out. Mr. Gale just said that, Your Honor, that Mr. Parker is a smart guy, even though he doesn't know Mr. Parker, and that he would never do anything. He would never carry out an act at Lifetime Fitness when there's all these witnesses. He just established that he could not have been in reasonable fear. And I think the linchpin, Your Honor, is what this court said earlier, which is he didn't go anywhere. He stayed at Lifetime Fitness for over 2 hours. That is not evidence of somebody who is in reasonable fear of your safety to go to Lifetime Cafe and go, slurp some smoothies while you're, this predator, this threat that just happened to you is still lurking in, Lifetime Fitness. So if you do use your common sense, it would suggest that there was no threat, no reasonable threat that Mr. Gale was concerned about, if for no other reason that he stayed at Lifetime Fitness and didn't leave. And he wants to try and make an argument that the account manager is not the general manager and had no authority to do anything. Obviously, this court knows you have a general manager at Lifetime Fitness, you have hundreds of employees, and an account manager who is walking Mr. Gale around is a representative of Lifetime that, of course, would have intervened if there was any threat that was made. So based on those factors, Your Honor, I would ask the court to deny the temporary restraining order against Mr. Parker, especially since Mr. Gale also confirmed there's been absolutely no interaction with him over the last 30 days.
Again, I have little doubt about what happened here. And Mr. Gale indicated how seriously he treats this, and this court obviously treats this conduct very seriously, these allegations very seriously, and that's why the court put this matter on calendar. The court did not have to put this matter on calendar for hearing, could have simply denied this ex parte application. However, based on the allegations here, there may have been a showing of either stalking or harassment, so that's why the court put this matter on calendar to get some additional information. I've already indicated what needs to be shown here, a reasonable fear that a threat would be carried out, or conduct that would cause a reasonable person to feel harassed and actually cause that feeling. I just can't make that finding here. I cannot make a finding that the conduct alleged here rises to the level of stalking or harassment. This, to me, appears to be a chance meeting at a busy place, a busy public place, and a single statement that was made. It was an unwise statement. It's an unfortunate situation that we've been placed in here, but I just cannot, and Mr. Gale indicated he felt bothered by this, extremely bothered by this, continues to feel that way, but that just doesn't rise to the level of harassment or stalking or aggravated stalking required for the issuance here. Because the conduct does not fall within the statutory definition of stalking, aggravated stalking, or harassment, this request for protection order is denied. So denied as to both, for both temporary protection order and extended protection order against Judge Miley, denied for temporary protection order against Mr. Parker.
Thank you, Your Honor.
Thank you, Your Honor. And this can be returned to Mr. Gale. And that completes the protection order calendar.